be seated. Call now, cause number PD 066523, 066623, the State of Texas versus Cedric Johnson.
Presiding Judge Keller, may it please the court. My name is Rusty Anderson. I stand before you today on behalf of the state in a direct appeal it filed following the suppression of statements and evidence discovered as a result of those statements from a defendant, the appellee, Cedric Johnson. The issues that bring the state before you in this matter are twofold. First, while the trial court never specifically identified when appellee was subjected to custodial interrogation, thereby triggering his Fifth Amendment right to interrogation counsel, the Court of Appeals opined that occurred at the moment of his arrest. However, no law enforcement agent asked him a question that met the Innis definition of interrogation until 6 hours after his arrest, after he was read and waived his Miranda warnings. Second, the context in which appellee uttered the statement and the statements he made prior to being physically restrained made his statements ambiguous. Though there was testimony from two detectives that their subjective belief was that he was expressing concern about his children and not about himself, those subjective opinions of the actual officers are not a proper substitute for the legal test that calls for the objective view of a reasonable police officer at the time.
Counsel, are you arguing at all that he revoked his invocation for a lawyer? Like, that was one of the arguments below. I didn't necessarily see that here.
That was one of the arguments below. I believe that the two issues that the state is presenting are stronger issues, which is why I narrowed the field, so to speak.
I appreciate it.
And really, the primary issue is really where I think the strength of the state's case is in this matter. As this court is well aware, there's a general three-step process to determine when the Edwards-Miranda rule applies. The state has never been in dispute that there was a testimonial statement. For those who are unfamiliar with the case, the statements reflected around after appellee was Mirandized, he made statements telling police that he had placed the body of a missing 18-month-old child in a dumpster. He then led police to that dumpster where they located the blanket he had wrapped the child in. Police then tracked the contents of that dumpster, which ultimately led to the discovery of the child in the North Texas landfill. So the state does not dispute that there were testimonial statements. The state also does not dispute that at the time that he made his statement in this case, which is what the focus is, quote, "Okay, I need a lawyer," end quote, that he was in custody at that time.
How did he get to the police station?
He appeared voluntarily. So the report that the child went missing came in at about 6 a.m. that morning. It was an all hands-on-deck situation that involved local agencies, DPD, Dallas Police Department, and also federal agencies. I believe the FBI was involved. I'm not sure if there were additional agencies mentioned in the record. But everyone was kind of in search and rescue mode at that point. They were interviewing family members. He was one of the family members that came to the police station at that time, and he stayed there while they were conducting their initial investigation.
I have a question. The Edwards rule, at least as restated here in Montejo versus Louisiana, is that once an accused has invoked his right to counsel, to have counsel present during custodial interrogation, he's not subject to further interrogation. The word "during," it seems to me, could have two meanings there. It could be that he invokes his right to have counsel during, as in whenever you question me or interrogate me, or it could be during, meaning in the midst of the interrogation. I wonder if you can help me clarify what that, if any courts have said which of those to choose.
So I think that kind of gets to the issue of the interrogation prong on this case. And to get to that question, you really have to look at Ennis and what it defines as interrogation. And Ennis is pretty clear that what interrogation means are, quote, words or actions on the part of the police that they should know are likely to elicit an incriminating response. It must reflect a measure of compulsion beyond merely being in custody. The issue of when really depends on the context, on a case-to-case basis, I would suggest. I believe, and the state submits that in McNeil.
If I can just interrupt you.
Sure.
Are you saying that the word during custodial, the word during can have different meanings depending upon the context? I mean, I think the words, it seems to me that means one or the other. It doesn't seem, I don't see how it could mean both. It seems like it either means that he invoked his right to counsel to be present during interrogation, meaning like when you interrogate me, I want to have a lawyer there, right? Versus you're interrogating me and I say, oh, I want a lawyer now, right? So there's two different ways of understanding it, and that's what I'm struggling with, and I'm wondering if there's some authority that could help me to reach the conclusion about which of those that it means.
I believe that under the case law, I don't know a specific case that lays that out, specifically the way that you're addressing it. The state submits under the case law that it is during the process of questioning, because that is what McNeil, Pacina, Griffith, Douthwaite, all of the cases that are relevant to this particular issue state is that if and that is the primary issue that brings the state here. If there's no questioning going on at the time, then the accused is not in a position to invoke that Fifth Amendment right to interrogation counsel. The Court of Appeals really hung its hat on the phrase from Miranda, and also reiterated Ennis of the custodial interrogation environment. And while that's not the test, it is the concept of the interplay between custody and interrogation and how those two affect each other and the rights of an accused, that protect the constitutional rights of an accused.
So, counsel, is your argument that he was not in custody, or that he was not being interrogated?
Correct.
Which one is it?
Both, actually.
No, I think the first question was he in custody?
So when he first arrives at the police station, he is subject to 2 voluntary interviews where he gives basically background information and then talks about the whereabouts of where the child is. At that time, and up until he is arrested on outstanding warrants from other counties, he's at the station voluntarily. His second interview, which is the one that talks more about the substance of where the child had ended. And he gets up and he walks out of that interview on his own to make phone calls. He has his phone the entire time during that interview. It's voluntary. So yes, there's questioning there, but he was not in custody at that time. He's arrested, which is pretty well identified in the record, at about 7:35 p.m. And from that time forward, until Detective Harris comes into the room approximately 6 hours later, he's not asked a question by law enforcement.
Did he mention he wants a lawyer before or after he was arrested?
So he was detained before he made that statement. Yes.
So he was detained.
Yes.
Had he been arrested on the outstanding warrants? So I'm getting at.
Yes. Yes, he was being held in custody, and I think under the definition of what custody is.
Okay.
For all intents and purposes, he was in custody.
Okay.
But at that
So
point,
really, the argument is that he was not being interrogated, and that's why he couldn't invoke.
correct, and that's what the rule requires. In order to, I think the issue that was really discussed at the Court of Appeals was whether or not this was an anticipatory
Invocation, that's right.
invocation. And McNeil is very clear that again was reiterated in Monteo, that a accused cannot invoke anticipatorily.
So that actually does raise a question for me. So say you have a defendant who is simply arrested. Before the police ask any questions, he says, "I want a lawyer." Is that enough to invoke his Fifth Amendment, or is that an anticipatory invocation? Would the police be able to ask him any questions after that, even though they've never asked him a question before, but they place him under arrest? Is that going to be enough to trigger his Miranda right to have an attorney, or his Fifth Amendment right to have an attorney? I'm sorry.
I think that depends on the context. So,
Okay.
and I think that's where we kind of get into the context of this particular case. I think at a pure reading of McNeil, no. The answer is no. That wouldn't be enough. They could Mirandize him later, and if he invokes again, then of course they would have to back off.
Okay.
But I think, practically speaking, you know, a reasonable police officer could consider that and decide, okay, we're not going to question him until either we get a lawyer, or we're just not going to do it at all.
Well, it's safer than sorry. It's better to be safe than sorry in that circumstance.
Correct.
Right.
Correct. But I think also the difference in that scenario is the word want. And in this case, what we have is a declaration from the appellee that I need to talk to a lawyer. And in prior cases from this court, especially, I want to make sure, Davis, the court has found that statements like that are declarative, and declarative statements are ambiguous on their face. They are not come in the form of a request.
Okay, but that's the other thing too. Like sometimes questions are seen to be ambiguous as well. So declarative statements and questions like, should I talk to a lawyer? That's ambiguous. I mean, it just seems like it becomes very easy for us to declare these things as ambiguous. There's always a way to say that.
Well, and but I mean, that is certainly one perspective.
Okay.
I agree.
Fair.
I agree. But it is. The state would submit very clear in this case that it was not a request. He didn't say, I want to talk to a lawyer. He didn't say, please bring me a lawyer. He didn't express that he wanted to talk to what he wanted to talk to a lawyer about, which is part of the ambiguity in this case.
Just to clarify something for me. So he goes down to the station voluntarily.
Yes.
We agree on that. At some point, he said, I either need to talk to a lawyer or I need a lawyer. And at what point in the timeline does the law enforcement discover that he has active warrants?
So
Before or after I need a lawyer?
Sometime between, before. So it's sometime between the end of his second interview and when he returns, comes back from that, and he is then picked up, arrested at the police station. So it is before he makes those statements that they find out that he has the active warrants.
So they know before he says, I want a lawyer, that he has active warrants and he's not going anywhere, right?
Correct.
And he had already been arrested at the time that he said, I want a lawyer?
Yes, he definitely meets the definition of custody under the law.
And I apologize for you said that declaratory statements are inherently ambiguous, and I cut you off on the argument you were going to try and make. As I understand it, right, and not to sort of get you back on track though, he's making declarative statements, but it's in the context of discussing concerns about his kids. So that's a little bit different than saying, I'm not going to talk to you until I have a lawyer, which would be a declarative statement, but it wouldn't be ambiguous. But he's saying this in the context of, where are my kids? I need to talk to my kids.
Correct, and there were two officers that testified at the suppression hearing. Both of them said that's what they thought that he was talking about, because when he initially comes up, when the issue comes up, he asks where his children are. He asked why they were being interviewed. He asked how they could be interviewed without him being present, and he expressed concerns about the children's safety. And to both detectives, both the ones that the court found not credible and the one that the court did find credible, basically testified that they thought that he was referencing his parental rights, which is a civil matter. But more than that, the Detective Harris, the detective that the court found to be credible, also said that if he had been present at the time when that statement was made, he would have asked a clarifying question, which is perfectly reasonable and permissible by an officer, but it's not required under the law.
Well, that actually gives me another question I kind of want to ask. So he says lawyer. He just says the magic word lawyer. I want a lawyer, right? Then, without regard to questioning on the part of the police, he volunteers, I'll talk to anyone as long as you take my kids. Can we consider that context, even though it comes after his arguable invocation of a right to an attorney? Or is that enough? Can we add that to the context to suggest an ambiguity in what he was requesting or not? Does it make a difference that he volunteered this versus that it was part of a clarifying question or not? I don't know. I'm just asking you.
Yes, the short answer is yes.
Okay.
And that was the direction I was going. I think if you take the statement by itself, you have ambiguity. If you add into it the context, you have ambiguity. And then if you, again, add what he says 8 seconds later, I don't mind talking to anybody as long as I know my kids are all right, that creates even more ambiguity in this situation about what he is saying.
Well, counsel, why shouldn't we just get rid of the ambiguity and say, he'd been previously questioned, he's placed under arrest, he says, then I need to talk to a lawyer. I mean, isn't that the easiest way out of this? And then we don't have to worry about the ambiguity. I mean, talk me out of why we shouldn't just go down that route.
Because the law requires that there be an analysis of whether or not he was subject to custodial interrogation. And the state submits that the prior courts, both the Court of Appeals and the trial court, stopped their consideration at the point of, was he in custody? That question is well settled within this case. He was in custody. But they never analyzed, well, was he interrogated? And the question, that answer is no, because he was there voluntarily providing questions to the police in an effort to help locate the child at that time, and according to the record, even before he was considered a suspect. And there are plenty of cases that have come before this court where, a person shows up voluntarily, says things voluntarily. That is not a violation of your constitutional protections. At that point, when he becomes detained and is in custody, the question then becomes, okay, when is he subject to interrogation? And the fact is, he was never subject to interrogation. No question was asked of him by law enforcement until Detective Harris comes in, reads him his Miranda warnings, he waives them, and then they proceed with interrogation at that point. And so that's the state's position under this first issue. When was he interrogated? And the question is, he wasn't interrogated until after he was Mirandized. And if that's the case, there's no violation of Miranda. There's no violation or intrusion on his Fifth Amendment right to self-incrimination. And it was an abuse of discretion to exclude these statements from.
But it doesn't count unless he's in custody, right?
I'm sorry, I'm not
I mean,
sure.
if he's not in custody, then the Miranda part is
Right,
irrelevant.
and that's why the first half doesn't count. But when you get him into custody after that,
But
then
the
you have to look-
custody began when he got arrested, right?
correct?
So, I mean, you can't have one without, I mean, you see what I'm saying? Like, you can't, there has to be a custodial interrogation. Like, so when the custody begins, you keep talking about ambiguity and context. I mean, talk me out of just saying, okay, once the custody began, by definition, the custodial interrogation begun, because you can't have a custodial interrogation without the custody part.
You're right, you can't have a custodial interrogation without the custody part. But you also can't have a custodial interrogation without the interrogation part. And that interrogation part is what is missing at that point.
Counsel, at the time that he was arrested, was it solely on his previous warrants, or was he identified as being charged with the offense?
According to the record, he was only arrested on his warrants. He was not considered a suspect in the underlying offenses until 90 minutes after his arrest, following the polygraph examination of his girlfriend, which Detective Harris explained created some ambiguity between his prior statements and what he had learned at that point. And it was at that point that he decided he needed to come back and interview the appellee. So he was not considered a suspect, and there wasn't even a probable cause to consider him a suspect until an hour and a half after his arrest.
And then at the time he asked for a lawyer, that was well before he was considered a primary suspect. Is that
Correct.
right? Okay.
Correct. But to come back to this issue of ambiguity, the ambiguity part is really the case state's second question. If he was subject to custodial interrogation, was his statement ambiguous? But the state's primary position, again, is that his statement at the time was not a proper invocation of the right to begin with, because he wasn't subject to interrogation. And
Counsel, let me ask you one question. Maybe I'm not hearing real well, so there's probably some things I didn't hear you say. But the way I understand it, he asked for a lawyer, he gets arrested, he's put in handcuffs, he sits in a holding cell for 6 hours in handcuffs, and you're telling me he's not in custody?
no, I'm telling you, he is in custody, but he was not ever asked a question by the police that resulted in words or actions that they should have known were likely to elicit an incriminating response. And that is what is necessary to have a custodial interrogation.
What role, I know you're out of time, this is a trial court's motion to suppress, or there's a motion to suppress and the trial court suppress the evidence. What role does the standard review, which requires us to defer to the trial court's determination, play in figuring out how to regard the ambiguity?
Well, I appreciate that question, because normally the standard of review in this case, of course, is bifurcated. Historical facts and issues that depend on credibility are generally given great deference on review, while non-historical facts that do not depend on credibility and the application of a lot of those facts are given a de novo review. The problem in this case, really, with the first half of that, is that the trial court's findings, the state would argue, are outside the zone of reasonable disagreement. And the reason for that is that the findings that this trial court makes, in some places are completely unsupported by the facts in the record. They don't exist. And in other places are taken out of context. And so I may be out of touch with current times, but my belief is that for something to fall into a reasonable zone of disagreement, then there has to be some support of it someplace in the record for that to be. The court misstates not only the timing of when Appley says, I need a lawyer, but the trial court phrased it in a way that sounded like it was a direct response to being arrested, and that wasn't the case in this situation. It wasn't immediate, as the court discusses, and the court even gets wrong which detective was doing the questioning at the time. The Court of Appeals did a good job of trying to clean that issue up, and its own facts, I believe, are more accurate than what the trial courts are. But I think that's problematic when you look at the standard, and I also think that would allow this court to take a look at the record on its own to make it the proper determination based on the evidence that is actually there.
I think Judge Erie had a question.
Thanks, I was almost resigned to not asking it, but so it sounds to me like you're asking us, or like we would prefer that we sort of announce a rule that every pre-Miranda invocation of the right to counsel should be presumed to be only a more general Sixth Amendment right to have a lawyer whenever you have to go to court, and not a Fifth Amendment invocation.
No, that's not the rule that the state's asking for.
Okay.
The state is simply asking for this court to follow McNeil, and that's what it has asked the lower courts to do. And I know this court has adopted McNeil and Pacina. I hope I'm pronouncing that right.
Pacina,
and
Messina.
but though those rulings were not followed by the lower courts, and that is the problem in this case, and that amongst the other issues that the state has raised.
Any questions? We want to thank you for being willing to reschedule your argument.
Thank you, Judge Keller.
The case is submitted.
Thank you.
Call Call now cause number PD 070323, Stephen James L6 versus the state of Texas.
May I proceed, Your Honor?
Yes, please.
Doug Norman for the state. May it please the court, counsel. This basically is a case where I raised two issues. One of them had to do with Rule 804 analysis of the unavailability of the witness, and the other had to do with the extent to which we can credit statements made by a prosecutor, which would indicate his good faith efforts to locate a witness. And in reviewing my briefs, I realized there were a few things that I probably was not as clear about, and I didn't flesh out as much as I could have. And so there are two issues regarding the first ground and one regarding the second that I really would like to flesh out a little more. The facts are pretty clear, and I'm sure the court has read the briefs and is familiar with it. I mean, if you look at the three key facts, I think, one is that the juvenile witnesses in question were deported and they lacked the legal right to re-enter the country. The second is that Texas itself was not responsible for that. The sheriff's deputies, when they arrested Mr. Elsick and realized they had illegal aliens, did what at the time they were required to do. They turned them over to U.S. authorities. And I realize that things may have changed a little in the interim, but at that time, there was no provision for Texas to retain and return the aliens.
Counsel, what
Yes.
good faith efforts did the prosecution make in order to secure the attendance of these witnesses?
I'm sorry, Judge, I didn't.
What good faith efforts did the state make to secure the attendance of these witnesses?
Well, the only thing we have in the record, Your Honor, is counsel's representation that he could not find. He was unable to find the witnesses, basically.
Did he indicate what he did to try to find them, or he just said, I couldn't find them?
No, he didn't, Your Honor. I admit that. He made a blanket statement, I was unable to find the witnesses. And I think that's key to the second argument I'm going to make. And I think that really, the first argument, if you decided on the first argument, then basically you're deciding it based on Rule 804, and it'll be limited generally to Rule 804. The second, and I really had qualms about whether to add that, but I'm glad I did because I think that's the more interesting argument in many ways, because that has the potential to affect any number of cases where counsel makes representations to the court, and the extent to which the court is allowed to credit those representations, even if they're slightly conclusory.
Well, but the question, the reason I asked the question what good faith efforts there were, other than him saying I was unable to find, isn't there a distinction between saying, here's what I did to try to do and I was unable to find something, versus I don't even have to tell you that I tried to do anything. I can just say I was unable to find them. Isn't that's the difference between actually making good faith efforts and making representations about good faith efforts and actually admitting that you made no good faith effort?
Well, I think, and here's the thing I think, Your Honor. When the prosecutor represented, I was unable to find them. He's doing that as an officer of the court, and he's doing that as a prosecutor who has a duty.
But didn't he also say, like, I'm not going to go ask the sheriff to go find someone when I know with a subpoena he can't go in somewhere else to go get it?
I think he did.
Yeah.
But I think his statement was that he wasn't going to do a futile act, which is try to subpoena somebody who's outside the jurisdiction.
I understand.
I think it goes back to, and the second argument, like I say, I think is a little more interesting. As an officer of the court and as a prosecutor who has a duty to exercise good faith in attempting to locate witnesses, can the trial court credit that prosecutor when he says, even a blanket conclusory statement, I was unable to find the witnesses, with having made some good faith effort to find them? And in many circumstances, and we're talking about abuse of discretion standard, so the trial court has some discretion. One trial court may not credit the prosecutor, another trial court may, and I think to a large extent it'll depend on the credibility of that prosecutor. Trial judges get to know the attorneys that practice before them, the prosecutors. There may be one prosecutor that the trial judge knows when that prosecutor says, I was unable to find the witness. He can be certain that that prosecutor has done everything under the sun to find the witness.
Then does this rule apply to defense attorneys being able to say the same thing? I was unable to find this witness?
I think it does. I think we'd have to admit that. I think we would.
All right.
But
Counsel, was there any questioning by the trial judge or raising of this issue by opposing counsel to try to discern what the prosecutor had done?
No, I don't believe there was. And opposing counsel, who happens to work for our office now, I have a great deal of respect for him. He did a wonderful job in preserving error. And so I don't fault him for not preserving error, but I do think this can be fleshed out a little more, and he could have fleshed that out. He could have challenged the prosecutor on that and said, Judge, I want to ask a few questions of the prosecutor. What efforts did you take? In the absence of that, the question is, can the trial judge credit the prosecutor's statements? As an officer of the court, as a prosecutor who we presume is exercising due diligence, can he credit those statements as having exercised good faith in trying to find the witness? And I would suggest this is not too much different than the presumptions we make with law enforcement officers. We presume that law enforcement officers, acted reasonably and in accordance with their duties, unless somebody shows us otherwise. What I'm suggesting is, when statements like this are made by the prosecutor, the trial judge should have the ability to credit them with truthfulness and with due diligence. And as I said, there may be some prosecutors that the trial judge knows, he's familiar with them, defense attorneys as well, and he knows when they say, I was unable to find the witness, that they exercised due diligence in doing it. There may be other attorneys and prosecutors that the trial judge knows that he can perhaps make the inference that they didn't even crack a phone book to try to find it. It depends a lot on the trial judge's knowledge of this particular prosecutor or defense counsel, and whether he believes as a part of his discretion that he can trust that. And I think this court in general, and one of the reasons in my supplemental brief I cited the McGuire plurality opinion. I realize it's plurality, it's not binding, but I think it suggests, where this court has kind of been going with regard to statements by attorneys and such, because I thought it was interesting that in discussing exigent circumstances, one of the things the court discussed was prosecutor's statements that while there might have been a judge assigned to be on call for that night, according to the prosecutor, the on-call judge was not always reliable or responsible. I mean, that's a blanket statement. It doesn't say why the prosecutor thought he was reliable or responsible, but it's a blanket statement which the trial judge was allowed to credit. I think that's an extremely interesting question that'll have broad-ranging effects, broad-ranging, interpretations or effects on the interpretation of law. That, I think, is an interesting question. If I may go back to the Rule 404, the Rule 804 analysis, there are a couple things that I would like to hit there, if I may. One of them is, I generally mentioned the ability through a treaty to obtain the presence of a witness, but I didn't really flesh it out enough for you, and I acknowledge that. In my supplemental list of authorities, I've cited a website by the Homeland Security Office, which has forms for obtaining a witness, and the Code of Federal Regulations, specifically for what I think, and admittedly, I'm not an immigration lawyer, but I think the S-5 visa, which provides for a law enforcement officer to obtain a witness or informant outside the United States, a visa for them to legally enter the country. I think that's the most appropriate one that could have been used in this case. But even that is not a good fit, because in order to bring that individual into this country, the prosecutor would have to show several things. An individual may be classified as an F-5 non-immigrant if, one, the Director of U.S. Citizenship and Immigration Services determines, in the exercise of his discretion, that the individual is in possession of critical, reliable information concerning a criminal organization or enterprise. Now, I would suggest that that's the situation where you have a witness against somebody like a cartel member or Al Capone, where you've got to get this witness in here to talk about the criminal organization. That's really not our witness here. Our witnesses are going to testify to nothing more than their birth date. So on a facial look at this, it doesn't even seem to fit. They also have to show the individual is willing to supply or has supplied such information to federal or state law enforcement authority. They have to show a willingness of the individual to come into the country. And finally, they have to show the individual's presence has been determined by the Attorney General to be essential to the success of, among other things, a successful prosecution of the individual involved in the criminal organization or enterprise. And not only that, but in applying for the visa, the law enforcement agency has to provide, along with the form, the alien's fingerprints, signature, color passport-style photographs, birth certificate or passport, and other biographical information. So there's a lot you have to do to get this individual into the country, even if that did fit.
Counsel, let me ask you a couple questions. So you used the word credit, and, you know, suppose in this case, the prosecutor says, I was unable to find the witness, and the judge says, well, that doesn't sound like that was enough. Is the judge crediting that testimony, but just saying that's not enough, or is the judge not? Like, you used the word credit. What do you mean by that? Do you mean that it's being accepted and weighed, or that it's being automatically believed? Like, what do you mean by the word credit?
I think it would mean that in his discretion, the trial judge is accepting that at face value as sort of an inference that he has exercised due diligence in doing so. And the trial judge is not required to. I mean, it's an exercise of discretion.
So if the trial judge says, I hear what you're saying, but that's not enough, in your mind, that doesn't count as crediting it?
I mean, I think that would be, if he says it's not enough, that would almost be discrediting it or challenging it.
Okay, and then my second question is, you know, so I guess the opinion uses the word juveniles. These two juveniles presumably are sent back to Mexico. You know, and you just talked about the requisites for getting this visa. You know, you talked about testifying against cartel and passport photos and all this stuff. I mean, what's to stop, a sheriff's deputy who knows a police officer across the border to go, hey, will you swing by these kids' school and see if they're willing to come over and testify? And let's say they have Mexican passports and they say, sure. I mean, there's just nothing here. I mean, I'm just struggling to hold on to something that shows, I mean, you talk about the procedures for getting this visa, but and we don't know because we can't prove a negative, but for all we know, you could have sent a police officer to their high school and they say, sure, I'll come to Mexico for a day and testify. I have a passport. I mean, it could be a hard situation to get these kids over there, or it could have been super easy and they could have just taken an Uber to the border, walked across, and then have a sheriff's deputy pick them up and take them to court.
Well, I mean, there was some Border Patrol testimony that they were in the country illegally, and unless you want to assume or unless you infer that somehow they, between the time, it's about a year's period, they applied for passports and were able to come into the country legally or somehow change their status, which I think would be an extraordinary thing to happen. And I'm not sure we have to exclude extraordinary circumstances like that. The Border Patrol deported them because they were in the country illegally. And it would be, I think, somewhat of a leap to assume that now they have the right legally to enter the country. If I may, the one other point that I think I probably need to address is one that was raised by the amicus. And they suggested, well, okay, if you can't get him here, present here physically, there are all these other things you could have done with their testimony. And the rule basically says it allows us to use a testimony if the witness is absent from trial or hearing and the state's proponent has not been able by process or other reasonable means, and we couldn't do it by process, so they must be talking about reasonable means, to produce the declarant's attendance or testimony. And I think what the amicus is saying, well, you might not have been get them here by attendance, but you could have gotten the equivalent of their testimony. And essentially, they talk a lot about depositions. Now, on the face of it, that might make sense unless you read the rest of the rule. The rule basically, the analogy I would say is that the first part here, A, is talking about the gold standard. The gold standard is testimony. And the silver standard is all those other things we can use if we don't have the gold. Well, guess what the first silver is that's mentioned? It includes deposition testimony in a criminal case under 3902. So essentially, they're saying it's both silver and gold, and I don't think they can do that. You know, effectively, they're saying, first you have to show that you couldn't get the deposition testimony, and then that's how you can get the deposition testimony in. That doesn't make sense. So I think that would be an unreasonable reading of the rule. It can't be internally inconsistent in that manner. I think what the rule is talking about is clearly in-person testimony, and that the other substitutes, like depositions, are only available if you don't have the in-person testimony. And the other substitutes as well, there is no hierarchy there. So we use one of them. The fact that we could have used another of them doesn't negate our ability to use the statement of personal and family history. Those are the main points that I wanted to make. There are a few collateral ones. I wanted to emphasize it's an abuse of discretion standard of review. So we're not saying that every judge faced with this scenario would have to find that the witnesses are unavailable. We're saying that this judge, under these circumstances, did not act outside the zone of reasonable disagreement. And I see that my time is up
Did you
almost.
reserve time for rebuttal?
I reserve 5 minutes, Your
Okay,
Honor.
thank you, counsel.
Thank you, Your Honor.
May it please the court. My name is John Lamberson. I'm here on behalf of defendant Stephen Elsick. This was a very, very simple case here in McMullen County. The question wasn't whether he was trafficking. The question was whether two of the people being transported were juveniles. That was the big fact issue in this case. It was an element the state was required to prove beyond a reasonable doubt. It raised the level of punishment from being 2 to 20 years to 5 to 99 years. The only evidence presented by the state of this element of the offense at trial was the hearsay statements of the DPS officer that these two had given their ages as being a few months prior to being 18 years old. The same trooper admitted that people lie. They lie for
Counsel,
the
should we draw a distinction between, say, someone who's out of state versus someone who is not able to enter the country legally for the purposes of this rule?
It would, I think, go to the balancing test that the court has set forth and the Supreme Court has set forth in what is due diligence, what is reasonable. Certainly the fact that somebody is illegal certainly changes what reasonableness would be. It certainly changes what due diligence would be, but it certainly doesn't change the fact that someone might be out of state and not being able to be brought back because they're not within the subpoena power of the district attorney's office.
Well, I mean, it's easier, like I'm getting at is that it's easier to subpoena someone out of state than it is to try and go to the hoops of bringing someone into the country who's not supposed to be there legally to come back in and testify.
Yes, of course, Your Honor.
Yeah.
Much easier.
So you say that it factors into the reasonableness. Is there any indication that the reasonableness, that it is unreasonable to expect the state to be required to bring someone back into the country who's not here legally to come in and testify?
No, Your Honor. And in fact, I believe that the amicus did a better job demonstrating that than I did because he's much more familiar with this than I am. But certainly we have the Mutual Legal Assistance Treaty now, which allows people to be brought back.
Okay.
As the amicus wrote in his brief, this was in 2022 when pandemic rules were still in place and people were allowed to testify via video. One of the cases I cited within my brief was Alley, which is a Fifth Circuit case. And of course, the rules for the feds are different than the state, especially as it relates to work permits and this and that. But they went through an entire test of what is actually reasonable from someone who cannot come back into the country, none of which steps were taken by the state. Indeed, the state didn't even have the contact information for these witnesses. They never bothered to gather where the witnesses were from, so how were they going to track them down? Which goes to, I think, the central paradox of the state's argument. On one hand, they want to argue that these were juveniles. Juveniles aren't automatically deported within the United States. Juveniles go to various programs, whether DACA, whether assistance programs. So if those juveniles went to those programs, they were locatable by the state. If they did not go to those programs, then they probably weren't juveniles. But the state made no differentiation nor made any attempt to locate them. They didn't run an NCIC, TCIC to see if they tried to re-enter into the country. There was absolutely nothing the state did.
So to summarize, you're saying that there are avenues that the state could have sought in order to obtain the attendance of this witness or their testimony.
Correct. I would say that if you're asking me if there's a bright line as to what the state should have done, I can't issue a bright line on that.
Okay.
That's why we use terms such as reasonable, correct?
Right.
I would say that certainly the state's unwillingness to get contact information for these alleged juveniles at the very beginning certainly made the state's job much, much more difficult to actually procuring them here for trial. That if the state had worked this case from the perspective that they were actually going to bring these juveniles back as witnesses, I suspect they would have done things much differently, even from the top. I do want to speak to...
Can you just clarify something for me real quick? So you've got a total of 13 counts. And so are those 11 adults and then 2 juveniles?
Correct.
And then do the juvenile cases elevate it to a first degree? Because I heard
Correct.
you say 5 to 99.
Correct. And which brings up a very good point.
And the 11 are second degree felonies.
That is correct, Your Honor.
Minor adults.
Basically, they were maxed out on each. So the defendant, Stephen Elsick, received 99 years on the 2 juvenile counts and 20 years of the remaining counts with a $5,000 fine.
And what you're saying is that the juvenile rules are different in the federal system as far as remaining here in the country, and they could have been more easily found.
Very good question. Yes, basically on three different levels. Number one, for example, none of us can issue a federal work visa or a federal permit to allow someone to come in under, which of course the feds can. Two, the feds are very aware of how you actually can do the various programs such as DACA and other juvenile programs. And then three, their ability to actually transport people throughout the United States is much, much easier. Again, we don't know if these alleged juveniles are even in the U.S. because nobody did an NCIC, TCIC to find out.
Well, counsel, there's nothing in the record about any of these things, right? I mean, none of this was discussed before the trial court.
That's correct, Your Honor. The trial court, as Mr. Norman put it out, the defense counsel did a very good job of preserving errors at least to all these issues, but the court did accept the blanket statement of the prosecutor, Mr. Sales, as it related to the unreliability or unavailability of the witnesses.
Whose burden is it in order to develop the record in that regard?
It is the state's burden to prove the inadmissibility or the unavailability of the witness, not the defendant's duty. Basically, they're asking for the exception to hearsay. We're not asking for the exception to hearsay. Therefore, it's their duty to build out that there was reasonableness.
Thank you.
Basically, and as it relates to Mr. Norman's point, as it relates to Mr. Sales and being an officer of the court, I've known Mr. Sales for 13 years. He's a very ethical prosecutor, but his subjective belief that what he's done is reasonable does not equate to the objectivity of reasonableness that's required by law. His belief that I did enough, and just his blanket statement, I did enough, it just doesn't get there, especially because nothing was done. This is a
Well,
bit.
do we know that nothing was done? What do we have in the record that says that nothing was done?
The Mr. Sales' statements that he spoke to his investigator and said, should we issue subpoenas? They decided that was not going to work. The issue that it was going to take hours and days in order to get visas, in order to have everyone come over pursuant to the new federal guidelines, and a variety of other statements within the record that simply we don't know where they are and we don't know how to find them.
But those are at least some things that were contemplated, and I'm wondering about Mr. Norman discussed the discretion of the trial court, right, in making a call on whether or not the state has reached the status of enough, right? Because, so can you speak to that? I mean, at what point did the state's failure to take one more step and learn one more thing by checking, say, TCIC, NCIC, at what point is that interfering now with the trial judge's discretion, right?
That's a very good question, Judge, and I will answer just to demarcate. It is an abuse of discretion as it relates to the judge's acceptance of the reasonableness of Mr. Sales. However, I'll argue it's a constitutional and foundational issue as it relates to whether or not you have the right to examine those who accuse you. And I believe there are different standards there that we can discuss.
Are we talking about an evidentiary question, a rule of evidence question, or a constitutional question?
I just did not want to waive my discussion as it relates to the standards that relates to the constitutional issue. But just, you're correct, discussing the evidentiary issue, it is an abuse of discretion. As to what that is, of course, you've read all the briefs. There's a lot of courts that have a lot of different opinions as to what can actually be reasonable. But you were talking about what other steps. I would simply argue they made no steps whatsoever. Not from the time of arrest, where they got no contact information, where they took no depositions, where they took no videos, where they did nothing except to interrogate to the time of trial. And you have to remember, the defense was asking for more time here to locate people and to find things. The state was the one pushing and pushing and pushing to take this to trial as soon as possible, but again, without making any steps whatsoever to locate people.
Let me offer you a hypothetical. If, let's say that there's someone who gives a statement to the officer, like the statements that were given here, but subsequent to that, the person falls into a deep coma, right, and is in a hospital. And everybody knows that, right? They're sharing information. Everybody knows that the guy's in the hospital in a coma and not likely to wake back up again, right? So what should the prosecutors do under that situation? Should they, consult more doctors, or, what's the reasonable good faith efforts that they should take there?
That's a really good question, and it actually speaks to Mr. Keller's reliance on Mancusi, which is the U.S. Supreme Court case he mentioned within his brief. In Mancusi, the alleged victim had been part of a trial. He had then moved to Sweden and was unavailable in Sweden. I believe he was in the hospital in Sweden at that time as well. But even in Mancusi, they were using the prior trial testimony rather than sui generis statements. Rather than, my apologies, that was the wrong way to use those words, rather than using them as current trial testimony. But they proved the witness was out of the country. They haven't even proved these juveniles are out of the country. They also subpoenaed.
I thought the record showed that they were deported.
They just assumed they were deported, but there's no actual proof of deportation. Everybody assumes they were, which doesn't make any sense. Juveniles aren't simply deported by the feds.
So would you have wanted the state to run TCIC on these two juveniles, supposed juveniles, based on what they said their names were and what their dates of birth were?
Correct.
And yet you're suggesting that they might have been lying about their age, for example. So wouldn't they also have been lying perhaps about their names? I mean, how much reliability can you really give under those circumstances to a claim of, my name is Joe Blow,
Well,
and I'm an illegal alien?
Yeah, I'm Joe Blow, I'm illegal, and here's my date of birth.
I have no ID. I mean, did they have ID?
They did not, I don't believe, Judge. But to me, that goes directly to the point that you can't say reasonably that we're going to use this solely as proof of the element of the crime that's going to send someone to prison for 99 years if we can't trust the reasonableness of who they are, where their contact information comes from. If it's inherently unreasonable to trust that they're giving truthful information, then certainly it's inherently unreasonable just solely on the basis of their one statement, their one hearsay statement, that they are juveniles.
Sure, counsel, but we're not here talking about sufficiency of the evidence, right?
Correct.
We're here just talking about the evidentiary issue.
Correct.
Right.
But
But how reasonable is it to say, well, if only they had run TCIC and CIC,
I think
that would have made a difference?
Sorry, Judge. I would say that pursuant to Mancusi, I believe that the reasonableness would be, one, reasonable efforts to make sure that the person is not within the jurisdiction, whether that's NCIC, TCIC, whether that is checking with the feds to see if they're within some particular DACA program, whether it be whatever, it's just something to show that they're not within the jurisdiction, which nothing was done here. Which again, in Mancusi, they made sure he was in Sweden. And then two, if they do locate them, even if they're in Mexico, an attempt to subpoena. That was, again, what they did in Mancusi, which was different than it was here as well. But at the very minimum, I believe those have to be a baseline in order for reasonableness as it relates to unavailability, none of which was done here.
So was it simply the officer saying, or the lawyer, the prosecutor saying, we don't know where they are, we can't find them, but take our word for it that two of these guys are juveniles?
But a little bit more nuanced than that, but basically, yes, Your Honor. They basically said, we do not know how to locate them, we cannot locate them, but we're going to offer the testimony. They first tried to offer the testimony of the local officer who did not speak directly to the alleged juveniles. Then they offered the testimony of the trooper who did. And that was the testimony that was accepted by the court and overruled as it relates to the 803, 804 argument. But yes, there are two issues we're talking about here. The first was the right to confront, and I do want to address that because that's an entirely separate issue as it relates to 803. The right to confront is absolute. We've held that U.S. Chambers, Ohio versus Roberts. It's been incorporated in Texas. The right to confront is absolute, and the right to confront was denied here. It wasn't.
Counsel, was the lower court's opinion based on the right to confront, or was it based upon the evidentiary ruling? Just the evidentiary ruling?
It was just based upon the evidentiary ruling, Your Honor. However,
So is the confrontation issue before us?
I believe it was adequately addressed within the brief that was submitted to the Court of Appeals, and therefore it can be before this court, yes, Your Honor. But just solely relating to the 804 evidentiary ruling, Your Honor, there's a very strict definitions, which I know are subject to ambiguity, but still unavailable by means by other process or reasonable means. It just simply doesn't mean that we cannot find the person. And again, this is not the only crime in Texas where there's an age issue of.
Well, what about a situation where you can't find the person? I mean, more to the point about the coma patient. What about a situation where look, they can't find this person? So why isn't that person unavailable? Why wouldn't that fit the definition of unavailable? We can't find this person?
Are we just relating it simply to what they're saying in terms of their date of birth, in terms of, like what's an exception to 804 are we talking about in terms of confrontation clause? I would suggest in terms of 804, medical records or a doctor's testimony that says this person is in a coma, but we need to prove up his date of birth. that would certainly be sufficient to prove unavailability. As it relates to confrontation clause, as to I saw the defendant shoot at me, that's not an exception to 804 and therefore would still be barred by the confrontation clause due to because
Yeah,
of the
but my larger point is that, look, if you can't find the witness, like, that's what the state's argument is. We just couldn't find the witness. There was not really any way for us to find the witness. Given the information we had, there was no way to do it. Why isn't that going to be sufficient to sort of say that the witness is unavailable?
Because the burden falls on the state, Judge. Because it's the state's burden to make sure that their witnesses are available or to procure mechanisms by which their testimony becomes available. Okay. That cannot be the defense's job. It cannot be the defense's job to travel to Mexico, investigate, try to find these people, then to prove up what their ages are. That simply cannot be the burden of the defendant. It's the state's burden.
Well, counsel, if the defense counsel suspected that these juveniles weren't actually juveniles, then wouldn't defense counsel have an obligation to attempt to investigate that issue?
I believe he would have. If I were the attorney for the defendant, I would certainly believe that's my obligation. But how is the defense attorney supposed to do that without the state procuring contact information for the juveniles, without an NCIC, TCIC, with any of these things? How is the defense counsel supposed to do that?
Investigator?
Even if the court gave the funds for an investigator traveling, they're not going to give $7,000, $10,000, $15,000 to travel to Mexico.
If they don't ask, they don't get it,
But even if they did, how are they supposed to locate them without the state even procuring the contact information for the people who came across?
well, they had names, and they could have, the investigator could have contacted the feds. The investigator could have taken similar action to what you're trying to, say the state should have done, and do you have proof that the state took no action at all?
Yes, Judge. I think it's very clear from the record the state did not take any action at all. But I would also argue that saying to the defense attorneys to prove the innocence of his defendant, or at least that not beyond a reasonable doubt as relates to one of the elements of the crime, impermissibly shifts the burden from the state to the defense in order who's actually got the burden of proof at trial.
No, I understand that, but of course, a defense attorney still has an obligation to investigate, especially if there's a suspicion that these people may have been lying and they weren't actually juveniles, and so that would have been, for effective assistance, that would have been something that defense counsel should have undertaken as well.
Whether or not defense counsel was effective or not, it's not been brought before the court. I do not know counsel's particular reasons for strategy as it relates to calling or not seeking investigators at the time. I know that they'd asked for more time in order to prepare for this case, with the judge saying she's going to hold their feet to the fire and make them go. I do not know if this was a strategy reason. I don't know if they were forced in trial earlier than they thought. I simply don't know, Judge.
Okay.
So they might have known, one way or the other,
Might have known.
whether the children were lying or not.
I do.
They wouldn't tell us, right? I mean, why would they be required to tell us, either through testimony or otherwise, if they thought the state had failed its burden?
Are you asking why the defense attorneys didn't?
Right, they might have known. Is there anything in the record showing they didn't know for a fact what age those children were?
Yes, Your Honor. That was the basis of their defense at trial, was that these were not juveniles, and that they certainly could be proven beyond a reasonable doubt that the ages. But that was the basis of defense at trial, was that that was their only basis of defense at trial, is saying, look, yes, we hit element 1, element 2, element 3, element 4, but you cannot prove element 5 because we have no basis to say that these are actual adults rather than juveniles. And again, there's a central paradox of the state's argument. If they were juveniles, they are still in the state. And if they're not juveniles, that's why they get deported. So, yeah, basically that was what I wanted to bring to the court, unless there's any further questions.
Thank you, counsel.
Thank you. I'll reserve the balance of my time.
If I may briefly, Your Honor.
Mr. Norman, I got a question for you before you start. Is there any record evidence in this case as to what, if anything, the state did to get these witnesses to the courtroom?
Just the prosecutor's statement, Your Honor.
Pardon me?
I concede just the prosecutor's statement that he was unable to find them.
No record evidence other than prosecutors saying, I couldn't get them here?
As far as I can tell, yes, Your Honor.
Okay.
That's true. I don't,
Is it your opinion that prosecutors always tell the truth when they're in the courtroom?
No, Your Honor, but you know, the judge, I think, in his discretion, can believe or disbelieve the prosecutor, and that's part of, you know, being there and seeing them and having knowledge of them.
Okay, I agree with you that sometimes prosecutors don't tell the truth when they're in the courtroom. But don't you think that if there was any actual record evidence as to what the prosecutor did to get these people here, he would have said something about what he did?
I think it would have been better for him to do that. I'll concede, it would have been better, but I think we're talking not about the best case scenario, but about, you know, in a sense, we really are talking about what's the least he could have done to get the trial court in its discretion to believe that he did exercise reasonable means. And he did a little more than just say conclusorily, well, I exercised reasonable means, or I did enough. He said he was unable to find the witnesses. And I think maybe there's a continuum here. How much do you have to put flesh on the bones until you have enough that the trial court can say, yes, I think you exercised reasonable means?
But he said he was unable to find the witnesses. That's different than saying, well, I did this, and I did this, and I did this, and it didn't work. All he said was I was unable to find them. You know, he didn't say anything that is record evidence as to what he did.
And I'm agreeing with you, Your Honor. I don't dispute that.
Okay.
The question is that enough to make these inferences?
Okay.
And he could have been challenged on it. In all fairness, the defense, if it didn't think he had, as an officer of the
Well,
court,
okay,
But
well,
don't you think if he did anything, and especially if he did enough to meet what he needs to meet here, if he did anything, he would have said it.
I would
But
have.
he didn't.
I would have if I'd been in his position. It definitely could have been a stronger showing, Your Honor. I think this is testing the limits of the showing that he would have to make.
well, that's why we're here.
And yes, Your Honor.
That's the business we've chosen.
And I would like to stress that I believe the testimony by the Border Patrol agent was that they had been deported. And so there is evidence that they were deported. I'd like to stress that the COVID rules were discretionary. The same judge who decided that Rule 804 had been met also could have said, I'm not hearing remote testimony anymore. As far as I know, all the testimony was live. So the COVID rules were permissive with the trial court, but not mandatory. The Coma example I thought was a very good one. And I think it begs the question of, how much is enough to show unavailability? Coma patients occasionally wake up. And Alzheimer's patients occasionally have lucid moments. But do we have to show that we brought them here and, on the off chance they'd have a lucid moment and we could get their testimony? I don't think so. I think it's a reasonableness standard.
Well, but is there a difference between saying, here's a coma patient, here's the evidence, or here's what we have, not just representations, but here's the evidence that we have that this person's in a coma, versus saying, well, we didn't try any of these things. We think that it would be futile, so we're not going to do it. That's kind of what they did in this case. I'm unable to find them, but here's the reasons that we don't think that we should have tried to find them.
I think it comes down to a reasonable standard, and as I said, how much you're going to credit the statements by the prosecutor that he was unable to find them.
Yeah.
I would like to suggest, and there's some suggestion that the sheriffs could have done more to preserve contact information, but I don't think 804 speaks to the duty of a sheriff's deputy before charges are ever brought. It's really directed to the prosecutor and those that are trying the case. Sheriff's deputies, are not familiar with the rules of evidence. Sheriff's deputies shouldn't be the ones to have to use reasonable means.
If I may ask one question. So what do you think about the opposing counsel's argument that if they had been juveniles, they would not have been deported?
I think that flies in the face of the Border Patrol's agent's testimony that they were deported. Oh, I'm sorry, you're saying...
Yeah. So would that mean they were not juveniles? Do we deport juveniles? Do we deport people that are approaching the age of 18? Is that just a given that we don't?
I don't think so, Your Honor. I think it's more complicated than that. To be honest, I'm speaking from somewhat of a position of ignorance, but there was testimony that they were deported. I don't think there is a blanket exception that says if you're juvenile, you never get deported. I think there are more programs for juveniles to process them. And I even think there was some testimony by the Border Patrol agent, but there was no indication that if you're a juvenile, you get a free pass and you can remain in this country as long as you want to.
Does anybody know who gets deported anymore these days?
Right.
Okay, thank you, counsel.
Thank you, Your Honor.
The case is submitted.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.
Judge Richardson.